Hi, this is your friendly immigration lawyer, Sasha Westerman Kuning, board certified by the Florida Bar in immigration law. And I wanted to make this video today mainly for my existing clients and potential new clients of mine who are obviously seeing all of the enforcement actions going around the United States with ICE and are understandably very, very nervous about the immigration process. And I am a very optimistic person. Anyone who knows me knows that. And although I like to think that everything's going to work out fine in the end for all of my clients, there are so many new and heightened risks that I am required to tell you about, right? As your lawyer. Now, I am known to be honest and direct, and this video is going to be very, very honest and direct. But I want you to remember that what I'm talking about here in this video are worst case scenarios. Okay, I want to be 100% clear about that. This video is about worst case scenarios, about what could happen to you, right? Not what will happen to you. And in fact, I think that statistically, this is going to happen to a very small number of people. But when we're doing risk analysis, we have to look at how serious the consequences are, right? The repercussions of our actions are versus the statistical probability of them happening, right? And so here we do have very, very, very severe consequences, right? And we want to take that into account when we are making our case strategy, even if we think that the probability is very, very low that they will happen, right? So just remember, I do believe that the probability of all these things happening are very, very low. And that's mainly a numbers game. There are literally hundreds of thousands of people going through green card processes each year, right? Inside of the United States and going through processes of extending and changing their non-immigrant statuses in the US. And so there are just so many, right? And even though we've been seeing reports of isolated actions, those actions do not affect statistically more than a few percentage of people, maybe like 1 to 3% of people, right? So it's very, very scary to see what's happening, but it's still affecting a very small number of people. And fingers crossed, everything's going to go fine in your case, right? So what are these risks I'm talking about? Now, historically, and if you consulted with me prior to the inauguration or even maybe February of 2025, I would have not advised you of any of these risks because they didn't exist. They just did not exist. I'm having to change and adapt how I practice the law every day right now under the current administration. And we need flexibility and we need patience as we learn new things, see new trends, right? Now, I'm very lucky because I am in a vast network of many vast networks of really good immigration lawyers, including a role that I hold for a national committee for the American Immigration Lawyers Association. And on that membership role that I have on this national committee, I do get a lot of access to data and information from other immigration lawyers. And most of what I'm going to tell you right now is relying on information from other immigration lawyers, right? Which I think are the best source of information because I cannot rely on the media. I see so many reports in the media that are either only part of the story or just not even true at all. And so I rely on the information from colleagues, especially ones that I know personally, all across the country to give me kind of what is actually happening in immigration, of course, and also what I'm experiencing in my personal practice, right? So again, these are talking about worst case scenarios, right? Now, traditionally, if you had asked me, am I okay in the US once my adjustment of status is pending? What is adjustment of status, right? That is when you're applying for a green card inside of the United States. When we're applying outside of the US, it's called an immigrant visa, and we do it through the US consulate. So this is for people who are inside of the United States and are applying for their green card under adjustment of status. People who have filed change of status, so they entered in one status, let's say a B2 visitor status, and now they're changing their status to something like student or a work visa, something like that. Or people who are inside of the United States and want to extend their current status. So that could be an extension of an H-1B work visa, an E2 investor visa, an extension of your B2 visitor status, right? So we've always told people as immigration lawyers that they are safe, I'm going to put it in quotations, in the US while their case is pending, right, with USCIS, whether it's adjustment, extension, or change of status, right? And the reason we've said that is because of a doctrine of law, which talks about having what we call, quote, an authorized period of stay in the United States, right? In an authorized period of stay, that language makes people believe that they are immune to immigration enforcement actions, right? And what I'm here to say today, and this may shock a lot of people, is that you are not immune from immigration enforcement actions when you are pending an adjustment of status, change of status, or extension of status. Even though you have an authorized period of stay, meaning that they know you're here, they know you're pending your new status, right? Whether it's green card holder, that extension, or that change of status. And there is no what we call unlawful presence, right? In the United States, right? Unlawful presence are days in the US when you are not here lawfully under a period of authorized stay. And unlawful presence becomes really important when if we have to leave the United States and depart the United States. If we have too much unlawful presence, we trigger a 3 or 10-year bar on reentering the United States, right? So that's all a period of authorized stay means, is that we are not counting days towards unlawful presence. And if we have more than 180 days of unlawful presence, we are subject to a 3-year bar if we depart. If we have more than 365 days of unlawful presence, we're subject to a 10-year bar if we depart, right? Those bars can be waived in a lot of circumstances with an unlawful presence waiver, but that's not the purpose of this video, right? So all a period of authorized stay in the US means is that you're not counting unlawful presence days. I know I just repeated that twice, but it's really, really important because I've been having to explain this issue even to immigration lawyers, right? Who do not understand the difference between an unlawful status and unlawful presence, right? And so I'm actually working right now on an article for the American Immigration Lawyers Association through my work on that national committee, a practice advisory for other lawyers on this issue, right? And so we know it's an issue that not only lawyers don't understand, but of course you guys don't understand, right? Now, that period of authorized stay, which also happens when, for example, I have an asylum case pending, right? And there's a lot of people who believe they're safe when their asylum cases are pending because, again, they're not accruing unlawful presence. So, for example, if I came in on a 6-month stay as a visitor and I filed for my asylum before that 6 months expires, a lot of people are under this false security because they're in an authorized period of stay, that nothing can be done to them. The same thing I'm going to say right now applies to people pending asylum cases as well, because all they're doing is not accruing days towards unlawful presence, right? Now, let's just take an easy fact pattern, right? When I come in, let's say on a 6-month visitor visa, like I was just mentioning with pending asylum, and before that 6-month stay expires, classic case, I got engaged to my US citizen spouse while I was visiting them. Now I decided I'm going to stay and married because I've gotten engaged, and now I'm going to file for my green card before that 6-month stay expires, right? Most people have been under the impression that because they filed their case, especially while they were in status, that there is nothing that can be done to them, right? That is not true. That is technically not true. From the day that an I-94 expires, a person is subject to what we call removability. And removability is just the word we use for deportation. The word deportation doesn't exist in the law anymore. So you will hear me say things like removal proceedings or removability or removal, and those are just synonyms for deportation proceedings and a deportation, right? We just use the word legally, the word is removal nowadays. Now, people are removable while those asylum cases are pending, those adjustment of status cases are pending, and in certain circumstances, while a change or extension of status is pending. And the reason is simply that the charge of removability, like if I was going to go to court and they were going to issue a court notice in a case like that, the court notice would say, I am not, they always start the same, I am not a native and citizen of the United States. I am a native and citizen of whatever country. I entered the United States on this date with an authorized stay until this date. You remained in the United States beyond this date, right? And then the charge of removability is visa overstay, right? So this is what we call a visa overstay. And the visa overstay charge is completely valid, whether there is an adjustment pending, a change of status pending, an extension of status pending, or an asylum case pending, right? It is completely valid, right? If I go to court, I cannot fight that removal charge, right? It says it's true, right? So if they ask me to say, is it true or not, I have to say true. Now, of course, if my adjustment of status case gets granted, if my extension of status gets granted, if my change of status is granted, if my asylum is granted, I'm no longer removable, right? But up until that point, I am technically removable from the time period that any I-94 expired until the approval of that pending case, right? And so, like I said, historically, we've always said that people were fine because they would just not take action against people, they being ICE, right? There was just an unwritten rule. And again, this is not the law, right? The law actually says the opposite. You are removable as the date of the I-94 expires, right? And so they are well within their legal rights to do this. But just historically, traditionally, in the 18 years I've been doing this and talking to, older practitioners, lots of them have been practicing for 40 years, just in all of those decades, they've never done this before up until now. Okay. And so this is a change with the new Trump administration. This did not happen when Trump was the president the last time. So this is something that has really sent ripples through the immigration community because we realize there's so many people who are pending statuses who are not fully protected, right? And like I said, they've been under false security that because their cases are filed, especially when they're filed in status, but frankly, it doesn't matter whether, especially an adjustment of status or asylum pending, whether it's filed before or after status expired, the person is not safe, right? In theory. Now, like I said, historically, there was an unwritten policy to do nothing against these people, right? And that's because it's silly. It's so silly, right? It's a waste, a massive waste of the court's time to have someone put into removal proceedings who, for example, is married to a US citizen, already has a green card case pending, or someone who, for example, filed an extension of their, H-1B status, and when the extension is granted, will not be removable anymore. Why would we waste time and calendar spots in the court's calendar? There's 3.6 million active cases in the immigration courts right now. Why would we add people like this to this horrible backlog we have, right? People can't even get court dates right now. Why would we add people like this into the court system? It literally makes no sense. It's so illogical. It's so inefficient. It's such a waste of resources. So this has always been the guiding principle, right? That because it's such a waste of resources, and it makes absolutely no sense at all, that we've just never done it, right? Like if my client had contact with ICE and, they had their receipt notices showing they married to a US citizen, they've got a green card case pending, ICE would leave them alone, right? They'd be like, if your case gets denied, and they want to take action against you, so be it. But until that case is decided, we're not going to take any enforcement action, right? Now, we've already seen instances where they are doing enforcement actions, right? Now, most of these come from one or two ways. The most common is through routine traffic stops, right? So just speeding, right? And I'm going to tell people, even if you have a valid US driver's license, if you have a case pending, you need to be so careful when you're driving, and you should be limiting your driving, especially in places like the state of Florida, because we now have 3 verified reports from members of the South Florida chapter of the American Immigration Lawyers Association, which I am a member of the South Florida chapter. I'm also a member of the Georgia in Carolina's chapters as well. And what we've seen with those three instances were routine traffic stops by Florida Highway Patrol, specifically Florida Highway Patrol, which is very common, for example, in the Florida Turnpike. And the person is given a notice to go to an ICE office the following week normally. And Florida Highway Patrol has been deputized by Governor DeSantis in Florida to do some enforcement actions for ICE, right? So they can't do what ICE does, but they can give a notice to go to the ICE office, right? So these people got notices to go to the ICE office. And when they appeared the following week, they were detained. They were taken into detention and put into removal proceedings, right? Now, I don't know the facts of all of them. I know the facts of some of them, but one of them was very disturbing because the individual entered on a valid B2 visitor visa, timely filed an extension of the B2 status before the 6-month expiration date, had the extension pending, but those extensions take months and months to go through. So the initial I-94 for the 6 months had expired, and the person was waiting on the approval of the next 6 months, right? And like I said, I do these cases all the time, done them all the time in the past, and I've always told the person, you're fine. You filed the extension before the I-94 expired. You have to stay in the United States. Frankly, if you leave, you abandon the extension request, right? So you're forced to stay in the U.S. while you're waiting. And it's just USCIS takes a long time. Sometimes they take more than 6 months to decide those cases. And I would tell the person to abandon after 6 months if they're only requesting 6 months, but that's a whole different story. But you have to stay in the US while those cases are pending, right? And so this person went to ICE. I said, the current I-94 has expired. The new case has not been approved. You're technically out of status, and we're going to detain you and put you in removal proceedings. And there was nothing the lawyer could do. They're right. Now you can file for a bond, right? So anyone that entered on a visa is going to be eligible to file for a bond with an immigration judge, but it can take a week or so, even longer, frankly, to get on the docket for a bond hearing. And it can also, like, for example, I charge between normally $5,000 to $10,000 to file just a bond motion and go to a bond hearing. If the bond hearing is far away from me, it's going to be upwards of $10,000. I'm just being honest, guys. You have to drop everything, write a bond motion. These motions are not short, do a bond package, and then attend a bond hearing, right? And so sometimes you can do them by a video, right, and save the client some money. But other times you have to go to the detention center and do the bond hearing in person, right? And so these are expensive cases. And because they're so time sensitive, we have to charge accordingly, right, as the lawyer. And so it's just not a situation you want to find yourself in, right? And so we've seen detention come up from these ICE check-ins that are started by a traffic stop, right? That's the first way. We've also had some reports of ICE detaining people at USCIS interviews. Now, on March 18th, had a client detained at his USCIS interview in the Miami field office. Now, my client did have an active order of removal. He had a deportation proceeding and lost decades ago. And so he knew. I had warned him, you're going to get detained, because by that point, I already knew that they would detain anybody with an active deportation order. And so that we knew, right? It wasn't a surprise. We were prepared for it. But what happened was about 2 or 3 days later, USCIS posted a Instagram post. Okay, I'm actually going to see if I can pull it up here. And that my client, his face, thankfully, is not in that post, but the agents that picked him up on that day are in that post, and that post is making reference to my client's detention, right? It talks about it talks about detaining 10 individuals in Miami that day, and one of them was my client, right? And so it's just very, very scary to hear that, right? Because we know that they are picking up a lot of people now at interviews. Not a lot. I said in the beginning, it's still very unusual. I will tell you that for those stories we're hearing of people getting picked up at interviews, there's hundreds of people not hundreds, thousands, literally thousands of people going to interviews that same week who did not get picked up, right? So one person gets picked up, 1,000 go to their interviews without a problem, right? And this is what I was saying about the probability of these things is still very, very low, right? So I don't want to make you scared to go to your interview. We got to go to our interviews. If we want to get our cases approved, we got to go to our interviews. But we have to know that there is a small, tiny, tiny chance that someone can get picked up in an interview, right? So here, I'm actually going to put it here. I wanted to see if I could share it on the screen. Here it is. So this is that USCIS post, right? It says, USCIS facilitated the arrest of over 10 illegal aliens at our Miami office. These aliens either overstayed their visas, had orders of removal like my client, or entered the US without inspection, right? And it was a very horrible post. They put people's faces in here. I mean, it's so demeaning and humiliating. I think there actually was a lot of backlash because of this post afterwards. But my client, like I said, was one of the 10 that was detained that day. And he had an order of removal. But that language of them detaining visa overstays is extremely scary to all of the immigration lawyers. Nobody knows the facts of that case. A lot of the local immigration lawyers that work in the South Florida chapter of the American Immigration Lawyers Association have claimed one of the 10, right? But nobody's claimed the visa overstay. It likely was someone that had no lawyer, right? But we don't know why, if there was a criminal record or anything like that, that caused ICE to detain somebody who showed up for their green card interview who was simply a visa overstay, right? And so that's caused a lot of concern for people, right? Now, like I said, I've been going to interviews. I have colleagues all over the US going to interviews, and most people are going to interviews, no problem, right? Like they're getting approved, they're not getting detained, and that's the majority. But I have to tell you, like I said, it's part of my job to tell you worst case scenarios that we are now seeing people who are just simply visa overstays with pending cases having some detention problems if they have an interaction with law enforcement or ICE, like an ICE raid or, like I said, a traffic stop. And they no longer have a valid unexpired I-94, right? Because they're technically removable. Now they can be bonded, but if you don't get bonded, which is completely discretionary by the immigration judge, then you have to fight your case, your removal case in detention. So it's very, very scary. And a removal case in detention, again, will cost tens of thousands of dollars in lawyers' fees. So these things are also a huge financial burden on people. And one of the things I'm going to tell people is you need to be saving up money in case you have any issues with a bond, detention, you're detained, you need a bond, or you're placed in removal proceedings at any point. These things are going to be expensive, right? And I honestly can't handle 100% of the bond and removal issues that could come up. I may have to refer out some of my clients to colleagues, trusted colleagues, especially depending on the location of the case. And these things are going to cost money, right? So I just don't want you guys to be taken off guard that we normally can fix these types of things, right? Either we do the case in court, right? A judge can grant a green card in court. And a pending green card case or a pending asylum case is a defense to deportation, right? So these are how we defend against deportation, how we win our cases in court, right? But they do not prevent you being placed in court, right? So they can't prevent you being placed in court, but they can defend against actually being deported, right? And so that's why it's important to have these cases filed, because they can defend against deportation, right? Now, really anyone with a unexpired I-94 an expired I-94 is vulnerable to this, right? And like I said, it's ironic because all of these cases require the person to remain in the United States. If you leave an adjustment of status case without a travel permit, leave the US while it's pending, you will abandon the case. If you leave a change of status or extension of status, you will abandon those cases, right? And so you're forced to stay in the United States during these cases, but you're also can get subject to removability, right? So it's a catch-22. It's a horrible catch-22 that we find ourselves in right now because we have to stay while these cases are pending, but we are vulnerable to removability and detention while those cases are pending. So they've really just made it such an unfriendly environment for people, I think, obviously on purpose, right? And I think they also want to cost people a lot of money, frankly. I think they are in a war, especially against lower income people. And they know that people like this will not be able to defend against deportation, right? And they will not be able to hire lawyers for bonds and all of these different things. And once you hire a lawyer for a bond can be set at $15,000, $25,000, right? And so they just know that they will price out so many people who will not be able to get help, right? Now, what can you do to protect yourself? There's not that much, obviously. Um, I was saying trying not to drive that much, basically like living like you're in a COVID lockdown, not going out that much, trying to stay home as much as possible, avoiding big crowds, avoiding places that will have, law enforcement, anything like that. The only way to prevent it at all is to do consular processing, not stay in the US for an adjustment of status, not stay in the US for a change of status or an extension of status and get the cases done through the consulate. But the consulate always has risks too, right? And obviously with adjustment of status, especially, you could be separated, right, from your spouse or your parent or whoever's applying for a lot of times up to 2 years doing consular processing. So nobody wants to be separated from the spouse for 2 years, right, doing consular processing. They'd rather be in the US together during adjustment of status. And so people just have to kind of weigh the risks of being separated from their spouses or their parent, children, whoever they're applying for adjustment of status, versus obviously having these risks, right? You just got to be really, really careful on your status, right? If you have an underlying status that you can renew, that's super important. Keep extending that I-94, right? So if I'm like a student and I marry a US citizen, I should stay in school, right? So that have my valid student status the whole time, right? So I cannot be subject to removability. If I have a work visa, I should be renewing my work visa while my case is pending, or DACA, or whatever status I have. I need to keep on renewing it. A lot of people don't want to do it because they don't want to spend the money, right? They're like, I already have my green card case pending. I'm not going to spend all this money on a renewal of my work visa because my case is pending. I'm really going to recommend against that. You got to renew everything, right? And for cases where premium processing can be paid for, there is no premium processing on green card cases. But for example, if I want to extend my H-1B visa or my E-2 status while my case is pending, I can pay the extra fee for premium processing and have that extension done very quickly so that there's not a big gap between when my I-94 expires and when my new I-94 is issued, right? It's something, some things will not allow you to do premium processing. You just got to wait, right? But where premium processing can be done, I recommend doing premium processing to have shorter gaps between I-94s. Also, starting your extensions and changes of status early before your I-94s expire. It's another way you can help to lessen the gaps, right? Unfortunately, we can't do extensions of like B2 status if we have an adjustment case pending because we cannot file asking for a non-immigrant visitor stay when we've already filed a green card case. They're going to say we're lying about being a non-immigrant and that we're misrepresenting ourselves, and that could lead to a fraud waiver. So we can't do that. Unfortunately, I would love to be able to protect people, but we cannot do that in that particular fact pattern, right? Now, traveling on advanced paroles, right, during case pendencies. Obviously, coming in and out of the airport has become a very high risk nowadays. The other thing is that if you travel on advanced parole, let's say I have a valid F1 student status, right? And I travel on my advanced parole, my green card case, I will be re-entered as under the parole and not in student status. I will lose that protection of having an underlying status. So, and a lot of times I'm going to advise against even traveling on advanced parole to make sure I can keep the underlying status and not give it up, right? So like if I have a work visa, it's not an H-1B or an L1, right? Like an E-2, an H-1B1, whatever. I may not want to travel on my advanced parole because when I come back in, I will not have the protection of whatever time I had left on my I-94 under that work visa, right? We've been telling everyone you need to have printed out copies of your I-94s, of your receipt notices. If you've gotten a work permit under case, always have your work permit with you so that you have some sort of whatever proof of status possible in case you do have a law enforcement contact. Those things, if you don't have a valid I-94, they're not going to prevent you from being detained or placed in removal, but who knows, maybe in discretion, ICE wouldn't take you into custody, right? So it's always good to have those. We also need to always make sure our addresses are updated with my USCIS, and that we are registering under the new registration program, although I'm recommending not to register until a lawsuit that's against the registration program is decided to see whether it stays or not. Like I said, if we get detained and the worst thing happens, we will have to file for a bond. The only people who cannot file for a bond with an immigration judge are people who entered on parole programs. So if I entered on the U4U Ukrainian parole program or the Cuban, Haitian, Nicaraguan, Venezuelan parole program, I am what is called an arriving alien. I'm not eligible for a bond with an immigration judge. So those people have a little bit bigger problems than other people. So I do think that people with any type of criminal record are at much higher risk of being detained at their interviews. That's just something we have to know, that criminal records, they are going after people, especially people with DUIs. We've been seeing lots of negative actions against people with DUIs. So just keep that in mind if you have some sort of criminal record, outside of let's say something super simple like driving with no license or something, you are definitely going to be at a heightened chance of removal proceedings or detention, right? It's just the way it is. If your TPS is going to expire, your parole is going to expire, you may very well be put into removal proceedings. If you have a pending asylum case, you may get called in for that asylum interview, and get placed in removal proceedings. We just gotta see what happens and adapt to whatever happens in the future, right? And hope and pray, fingers crossed, that everything works out, right? I'm very optimistic. I want to think that everything will work out, but it's important we know that these things could happen. So far, we haven't seen problems for people entering on ESTA. I have been concerned that after the 90-day ESTA period expires, that because when we do our ESTA registration, we can send to an administrative order of removal, that we may see more of that. So far, it hasn't happened yet. It could happen in the future, and then that would make ESTA entrants more vulnerable when they go to their eventual green card interviews. But right now, we're not seeing that yet. So that's just something that could happen. Hasn't started happening yet. No reports of that yet, right? But we have seen a huge influx of very old asylum cases getting interview notices, and they seem to be really trying to start getting that asylum interview line rolling. So we're just seeing it more. And of course, if we get called in for our asylum interview, we got to go. And if we don't win our asylum case, we're going to be referred to immigration court for removal proceedings. And our marriage case or whatever case is pending will get switched over to immigration, to the immigration court, right? Now we are seeing a huge amount of new interview notices. I think everyone's going to get interviewed from now on. Although we did just have a case, I'm recording this on April 7th, 2025. And just yesterday, we got an alert over the weekend of a approval through the mail of a green card case for a parent of a US citizen. So they're still doing some green cards without interviews, but we're starting to see it on pretty much all the marriage cases. And I know colleagues who, for example, have gotten interview notices for parents of US citizens, minor children of US citizens. So we're seeing a lot more interviews right now. And of course, with a lot more interviews, we expect the lines for processing to go up. I do think green cards are going to start taking 1 to 2 years to process, which just means it's a much longer time to be vulnerable, right? And just having to be careful. We're also hearing reports that interviews are taking a really long time. Like when people are going to interviews, that they're upwards of 1 to 3 hours as opposed to 30 to 45 minutes, and that they're being asked tons and tons of questions, right? So that's another thing. We just need to understand that we're probably going to have a very intense interview process, right? Now I'm here for you guys, right? You're not alone. I'm here for you guys. And again, these are worst case scenarios. Worst case scenarios, probably, hopefully not going to happen to you, but these are just updates these are warnings I had never given out before because we didn't need to. It never happened before, right? And now, of course, when I'm with new consultations, I'm informing them all of this right now. But with people that already have pending cases, unfortunately, this just was not something we had to worry about before. And fingers crossed, everything's going to work out fine, guys. Okay, I'm going to stay optimistic. We are preparing for the worst, hoping for the best, saving up money in case we need it towards deportation defense, and just having a positive attitude, positive thoughts, that everything will work out okay, right? I need you all to stay positive with me, because if we are negative and we dwell on everything that could happen or think that it will happen, we are going to invite that into our life. We are going to manifest that negativity into our lives. And I do not want to do that for myself or for you guys. I am going to think that everything's going to work out okay. Okay. All right. Well, if you have any individual follow-ups, I recommend that you go to my website and you book a follow-up appointment. So you can be on my calendar. We can discuss this more if you have individualized questions. But for right now, just keep living your lives. Try to be as cautious as possible. Try to decrease your public presence as much as possible. Stay home as much as possible and decrease those risks of exposure. Okay. All right, everyone. Good speaking with you. Have a great day.